Good afternoon. Today, my name is Kristen Corgido Maddie, and today we're going to review case Illinois versus Roy I. Caballes, case number 543 US 405, Supreme Court of the United States, January 24th, 2005. We are going to begin with the relevant facts. Illinois State Trooper Daniel Gillette stopped the respondent, Roy Caballes, for exceeding the speed limit on an interstate highway. The state trooper, Gillette, then radioed in the stop, and a second trooper, Mr. Craig Graham, Illinois State Police Drug Interdiction Team, heard the transmission and arrived at the scene with his narcotics detection dog. The state trooper Gillette was writing a warning ticket and soon to release the respondent, while Mr. Graham walked the narcotics dog around the car of the respondent. The dog then alerted of drugs at the trunk of the vehicle, and based on the alert of the dog, the trunk was then searched and found containing marijuana. The respondent was then arrested, and the entire incident took under 10 minutes. Next, we're going to review the substantive facts. The narcotic dog sniff, which was conducted under a lawful traffic stop under Mr. Gillette's stop due to excessive speeding, reveals no information other than the location of an illegal substance. And because no evidence of possessing drugs and or drug use on behalf of the respondent, this is out of the ordinary process. And it has the potential to violate the Fourth Amendment. As mentioned previously, the state trooper, Daniel Gillette, was in the process of writing the respondent a warning while the dog sniffed the vehicle without reason. The drug sniff was done without a warrant and without a reasonable cause, and therefore potentially in violation of the Fourth Amendment. The procedural facts are next. The decision to move forward with a warrant in search of drugs for a routine speeding traffic stop begs the question of why Mr. Graham chose this particular stop to arrive at the scene for this particular speeding stop on the vague chance that the respondent could be in possession of drugs. The applicable laws, the decision to move forward without a warrant in search of drugs for a routine speeding traffic stop begs the question. The applicable laws are official conduct which does not compromise any legitimate interest in privacy, is not search subject to the Fourth Amendment, and any interest in possessing contraband cannot be deemed as legitimate, and thus governmental conduct that only reveals the possession of contraband compromises no legitimate private interest. This is because the expectation that certain facts will not come to the attention of authorities is not the same as an interest in any privacy that society is prepared to consider reasonable. The remedies that are sought from plaintiff to the defendant, the court should find in favor that a narcotics dog sniff only reveals the presence of general location of contraband, but does not constitute a search, as it was in plain view to the dog's senses. From defendants to plaintiff, the court should find in favor that a narcotics dog sniff only reveals the presence and general location of the contraband, but does not constitute a search, as it was in plain view of the dog's senses. The issue, the dog sniff conducted during a lawful traffic stop during Mr. Gillette's stop due to excessive speeding, reveals no information and has the potential to violate the Fourth Amendment. As previously mentioned, the state trooper, Daniel Gillette, was in the process of writing the respondent a warning while the dog sniffed without reason. The drug sniff was done without a warrant and without a reasonable cause, and therefore potentially in violation of the Fourth Amendment. The holding. Accordingly, the use of a well-trained narcotics detention dog, one that does not expose non-contraband items that otherwise would remain hidden from public view during a lawful traffic stop, generally does not implicate legitimate privacy interests. In this case, the dog sniff was performed on the exterior of the respondent's car while he was lawfully seized for a traffic stop. Any intrusion on the respondent's privacy expectation does not rise to the level of a constitutionally cognizable infringement. The reasoning. When examining this case, it should be clear that the dog sniff did not constitute an illegal search, and the resulting seizure was not illegal, and the length of time the respondent was held was not unreasonable. Therefore, the evidence against Caballes should not be thrown out. Upon evaluation, in my humble opinion, this case was correctly decided since the defendant was in possession of contraband items. Otherwise, how else should the law enforce and provide consequences for those breaking the law? Thank you.